Hello, my name is Shania Holt, and for my presentation, I am talking about missing and murdered Indigenous women. It is a movement that has become popular in the past few years for very many drastic reasons. According to the Department of Justice, Native American women on some reservations are murdered at 10 times the national average. Although there are some reports and statistics, it is very difficult to find an accurate number or percentage of missing and murdered Native American women in the U.S. In Canada, a report found that little over 1,000 Native women were murdered between 1980 and 2012, but activists have identified over 4,000 missing or murdered Indigenous women. This is what led to the Missing and Murdered Native American Women movement that is on social media today. There is even a road in British Columbia called the Highway of Tears, where over 40 Indigenous women have gone missing or been found murdered. In 2016, a National Crime Information Center reported 5,712 missing Native American and Alaska Native women in the U.S. But experts say the actual number is higher because so many cases are underreported. This has been a prominent problem on the Yakama Nation reservation. The Supreme Court has ruled tribes don't have jurisdiction to prosecute non-natives for crimes committed on tribal land. This causes a problem when 90% of Native women who have been sexually assaulted said their assailants include at least one non-Native perpetrator. Therefore, justice is nearly impossible for missing and murdered Native American women with the prevalent jurisdictional issues in Indian country. I am going to try to explain jurisdiction in Indian country and how it became a barrier for tribes when it comes to missing and murdered Native American women. In a criminal case, jurisdiction is a power or authority of the court to try and punish the accused of a violation of a government penal code. Indian country is all land within the limits of an Indian reservation, under the jurisdiction of the U.S. government, notwithstanding the issuance of any patent and including rights of way running through the reservation, all dependent Indian communities within the borders of the United States. Whether within the borders of the acquired territory, therefore, and whether within or without the limits of estates, and all Indian allotments, the Indian titles to which have not been extinguished. But jurisdiction in Indian country becomes more complicated when the Supreme Court allows different entities to become involved with crimes occurring in Indian country. The U.S. Supreme Court decision, Oliphant versus the Squamish Indian Tribe, limits the ability of Native nations to try and punish non-natives. Under this decision, Native nations generally do not have jurisdiction to prosecute non-Indians. The General Crimes Act is a federal statute that provides that the federal courts have jurisdiction over interracial crimes committed in Indian country. And the Major Country Crimes Act provides for federal criminal jurisdiction over 7 major crimes when committed by Indians in Indian country. Over time, it has increased to 16 offenses currently. The states generally do not have jurisdiction over crimes occurring in Indian country with 3 exceptions. First being Public Law 280. In 1953, Congress authorized states to exercise jurisdiction over offenses by or against Indians. Public Law 280 provided for broad state, concurrent criminal jurisdiction on those states and reservations impacted by the act. And some tribes have been affected by federal legislation in which states have received a federal mandate to exercise jurisdiction outside of Public Law 280 through statewide enactments, restoration acts, or land claim settlement acts. And the U.S. Supreme Court ruled that state courts have jurisdiction to punish wholly non-Indian crimes in Indian country. Here is a chart to explain how different crimes are dealt with in Indian country. As you see, jurisdiction in Indian country is extremely complicated because federal, state, and tribal all have jurisdiction authority. Therefore, the lack of data and justice for the missing and murdered Indigenous women can be due to the complications that arise between the different entities that are allowed authority on Native American reservations. The issue directly affects the Yakama Nation reservation and has since the 1980s. At least that's what the reports claim. but the oral histories of the Yakima people claim there are much more women that went missing or were murdered and did not receive media attention. Many people remember there being so many missing and murdered women during a short period of time that they believed it was a serial killer. Unfortunately, tribal courts have not had jurisdiction to prosecute non-Native members of many crimes like sexual assault and rape, which has provided immunity to many non-Native perpetrators. The Violence Against Women Act and its reauthorization in 2013 was a step in the right direction because it provided special domestic violence criminal jurisdiction to federal recognized tribes. But federal recognized often decline to prosecute crimes that have been committed on Native American land, which in turn creates a jurisdictional black hole that many describe as open season on Native women on reservations. Another bill that contributes to resolving the issue is Savannah's Act. This bill was proposed by North Dakota Senator Heidi Heitkamp and named for Spirit Lake tribe member Savannah Graywin, 22. Who disappeared from her apartment when she was 8 months pregnant and was found murdered. According to the previous information talking about police and how jurisdiction plays a part in it, it obviously shows that there is a lack in police response. Many family members of women who have gone missing or were murdered are still looking for answers, sometimes decades later. This bill would require data collection and remove barriers to help tribal law enforcement to seek justice. But because of the conflicting jurisdiction issue, implementing Savannah's Act can be tricky if it is passed. Executive Director of the Minnesota Indian Women's Sexual Assault Coalition says, "We're not seen or heard from in the media when we go missing. I don't think the question is whether or not Graywin was murdered because she's a Native woman. I think the question is why is there an invisibility and why are Native women at higher risk for experiencing this type of violence?" Many Native American women like Nicole Matthews are taking matters into their own hands and starting coalitions and movements to bring more awareness and advocate for change. For example, on the Yakima Nation reservation, they hosted the Longest Walk movement this past spring. The Longest Walk is the final phase of a 3-year historic walk across America seeking solutions to drug abuse and domestic violence of Native American communities. At this event, the Native Victims Resource Program included this representation of red dresses and shawls honoring the missing and murdered Yakima women that took place on the Yakima Nation reservation in the 1980s and 90s. The Yakima Nation Victim Resource Program was created to support and identify the victims and communities through a comprehensive approach that would create stability by promoting awareness, intervention, and healing. Therefore, it is inherently important for Native American communities to take steps to find resolutions and build awareness for issues that plague Native nations. Oftentimes, issues like this go unnoticed because they occur on desolate reservations dedicated to minorities. In order to create change, we as students need to bring awareness to these type of issues and try to understand why these crimes are going unnoticed.